to request Israeli citizenship, but these conditions include, among other factors, swearing an oath of allegiance to the State of Israel. And I just need to stress that this requirement in itself is a violation of international law, which provides that protected persons under international humanitarian law cannot be compelled to swear an oath of allegiance to an occupying power. So this system of residency revocation and how it has evolved is referred to as silent transfer or quiet deportation. And it has evolved in a number of fundamental ways throughout the decades. From the mid-1990s, Israel has been implementing a policy of residency revocation of Palestinian East Jerusalemites based on a policy known as the Centre of Life policy. This means that permanent residents, or East Jerusalem permanent residents, are called upon to prove through rigorous processes that their centre of life has now remained in East Jerusalem for the last consecutive 7 years. So within the last consecutive 7 years, their centre of life they must be able to show that their centre of life has remained for the last consecutive 7 years in East Jerusalem. And throughout our work, we've heard many accounts of Israeli authorities in their investigation of the Centre of Life policy going to the extent of checking beneficiaries' fridges in their own home to check that the food has not gone out of date, to investigate whether or not their centre of life has indeed remained in East Jerusalem. So in 2014, the residency of 107 Palestinian residents of Jerusalem was revoked, and since 1967, between 1967 and 2014, 14,416 Palestinian residents of East Jerusalem have had their residency revoked. 14,416. So recently, we're witnessing the emergence, or at least the concerted application of extremely worrying trends in this regards. Following the latest escalation of violence in Jerusalem, the Prime Minister Netanyahu announced in September 2015 a consideration of the revocation of residency rights of those Palestinians who are living within the municipal boundaries of East Jerusalem, but located on the other side of the wall, as my colleague has explained earlier. The estimated number of Palestinians, under our estimates, residing on the other side of the wall, but within Jerusalem municipal boundaries as annexed, is about 100,000 Palestinians who could face having their residency revoked. While not many more developments have happened along these lines since then, the fact that it's been tabled for discussion and consideration is extremely worrying. Furthermore, on the 21st of January of this year, the Minister of the Interior of Israel revoked, on the grounds of a breach of allegiance to the State of Israel, the permanent residency of 4 East Jerusalemite youths, Palestinian youths, who are suspected of having carried out attacks against Israelis. And this decision was made despite the fact that the criminal proceedings are still ongoing and no determination of guilt has been yet reached. Nevertheless, they've had their residency revoked as a punitive measure. And it should be noted that under domestic Israeli law, under the Entry into Israel law, which regulates the status of permanent residency, it doesn't establish any specific criteria upon which residency can be revoked. However, under the citizenship law, a breach of allegiance to the state is one measure which can lead to the revocation of citizenship, but this cannot happen and citizenship cannot be revoked if the holder of the status being revoked doesn't have permanent residency to fall back on. Therefore, they cannot be rendered stateless. However, if a permanent resident is to have their status revoked, they are therefore rendered stateless in violation of international law. And this mechanism isn't available in the revocation of permanent residency. Furthermore, this bill being currently proposed before the Knesset also allows for the punitive revocation of the residency rights of spouses and children of those suspected of having carried out attacks, which I don't need to tell you is a blatant violation of the right of freedom from collective punishment. This bill, should it be brought into action, would firmly establish revocation of residency as a legal instrument in the Israeli legal system by providing the Interior Ministry with explicit legal basis for future punitive residency revocations. And just to tie this in the last few minutes, this needs to be viewed in the framework of international law as it applies to the occupied Palestinian territories, whereby Israel, as the occupying power, is primarily tasked with providing for the well-being of the occupied population. And the current content of this duty is further spelled out in the Hague Regulations and the Fourth Geneva Conventions. Israel is also bound by international human rights law, as was acknowledged by the International Court of Justice. And in its duty for upholding the well-being of the protected population, Israel must refrain from the forcible transfer of Palestinians as occupied population. In the establishment of a coercive environment, such as is the case in East Jerusalem, this robs Palestinians of their genuine consent to remain in their homes. Such mass or individual displacement, forcible displacement, absent genuine consent of one or more persons through expulsion or other forms of coercion from a location where they are lawfully present to another location within a national border amounts to forcible transfer. Forcible transfer is a grave breach of the Fourth Geneva Conventions, and this imposes and triggers third state responsibility and demands that third states cooperate to bring to an end any such breach, to refrain from recognising as lawful the situation created by such breaches, and to demand the performance of reparation obligations of the offending states. And I'll leave it at that for now. Thank you.
I thank Ms. Higgins for the richness of her very factual presentation. I'd like to express the committee's sincere appreciation for your participation in this meeting. Ladies and gentlemen, we still have one speaker and also the question and answer. Before we proceed with our discussion, I would like to invite you to a short coffee break. We shall reconvene in 10 minutes. So the time now is 12 past, so let's make it 25 past. We will reconvene at 25 past 4. Thank you.